Unfortunately, once an addict, they're always an addict. It's just a matter of dealing with that issue the entirety of their life, it seems like. So, Mr. Daniels asking that again for adjournment of the pretrial. I don't think we need very much time to figure out ultimately a
This
resolution.
opening line hits hard. This is where the court immediately frames addiction not as a moment, but as a lifelong legal and human struggle. But the real question is, should the justice system treat addiction as punishment or ongoing medical care?
A resolution in the case, a few weeks, whatever fits the court schedule best. And again, if you would consider on his bond on the contempt, allowing him to be released with testing, whatever regimen the court would require.
Mr. Coast, you had made a recommendation regarding treatment, keeping him in jail but allowing him to go to treatment. You would like to recommend him being evaluated by CMH for substance abuse services at the jail. You're muted, Mr. Coast.
That's correct, Judge. I mean, I think it's the best option to keep him sober.
Okay, Mr. Vanetto, would you like to weigh in?
I agree with Mr. Coast, Your Honor. Mr. Murphy is 100% correct. I believe his client is still suffering from his substance abuse addiction. However, I think just releasing him out into the world is only setting him back up for failure. I think if we can get him into a treatment program, maybe help him get out on the right foot, that would be better in this case. The offer itself is not predicated on Mr. Daniels completing rehab. What Mr. Murphy and I had discussed, I think, was if he does complete rehab successfully, I would then kill a bird and no upfront jail. But the offer that I extended to Mr. Murphy is not predicated on him completing rehab.
Thank you for clarifying that. Sorry.
So, Mr. Murphy, I am not going to release your client on a pair bond. I mean, I have to say people show up for court high all the time. But, Mr. Daniels is in the thralls of a severe addiction right now, and I'd rather get him services to try to prepare him for release. So I am going to order that CMH evaluate him for substance abuse services within the jail. We can address further treatment at the next hearing date, whether that be inpatient or otherwise. He failed to report, and as I said, he was, under the influence when he appeared. So I'm going to set this for April 29 at 8:30 in the morning. So a pretrial for April 29 at 8:30 in the morning on both files, and his bond's continued. Is there anything else we need to address today?
Not from the people.
Matt, I'm going to go ahead and do the paperwork for CMH.
Okay. Nothing further from the defense, Your Honor. Thank you.
All right. So, Mr. Daniels, we're going to try to get you as much help as you can. All right. Thank you.
I appreciate it, Your Honor. Thank you.
Thank you.
Mr. Daniels, I'll come talk to you soon, okay?
All right.
Thanks.
Okay. So, I did that one.
Your Honor, I
Miss
think that's all that I
Adams?
had. I was going to log off now, if that's okay with you.
Okay. Thank you.
Thank you. Everyone
Miss
have a good day.
Adams, you too. Nelson, I have no one. Let me see here. Termination order. So, Ms. Adams, in the matter of the people of the state of Michigan versus Walter Douglas Nelson II, file number 25-22209FH. Brian Montoy is the attorney for the defendant. I do have a statement order in the file from November 14. And neither party has appeared. Have you heard from Mr. Montoy? Mr. McCready?
I have not.
Perhaps, usually Mr. Montoy appears. So, Ms. Adams, if we could reach out to him maybe. Okay, so, took care of that one. All All right, are you D'Angelo Williams?
Yes, ma'am.
Good morning. All right.
D'Angelo.
All right, so this is in the matter of the people of the state of Michigan versus D'Angelo Monte Williams, file number 23-21309FH. Mr. Williams is appearing in pro per, and I have Jennifer Bruggeman appearing on behalf of the people. So we are here today on Mr. Williams' motion for restoration of appellate rights. And Ms. Bruggeman, you did receive this.
I did, Your Honor.
All right, and so Mr. Williams filed this asking for his restoration of his appellate rights. And then he went through the difficulties that came before he filed this motion. So Ms. Bruggeman, would you like to respond?
Yeah, Your Honor. I didn't file an answer simply because the way that the court rule reads, if somebody files a motion within 2 years, and he, from the final judgment, he narrowly met that 2-year mark, but in light of what he's indicating in his motion, and then the court rule itself and how it reads, and I don't have any objection per se. I just leave it in the court's discretion.
All right. So, Mr. Williams, the time period was reasonable that this was filed under MCR 6.428. The court does have discretion once the court makes a finding that the delay was not caused by the defendant.
This is a major turning point. Restoring appellate rights can completely reopen a defendant's legal future. But here's what people miss. This isn't a win on guilt or innocence, it's a procedural reset. How often do cases really change after this kind of ruling?
In this case, you did plead the facts that you had moved facilities. There were some periods of mental illness and lack of knowledge of the criminal justice system and the process required. So I am going to grant your motion and order restoration of your appellate rights. And so I guess, and that is supported by the court. We had a competency exam, among other things. You were sentenced on, it looks like, maybe March 8th of 2024. So do you need your appellate rights mailed to you again, Mr. Williams?
Yes, ma'am.
Okay, so Ms. Adams and Mr. Williams, are you currently at Ionia Correctional Facility?
Yes, ma'am. Yes, I am, Your Honor.
Okay, excellent. So we will mail those out to you today, and they'll probably have you initial and date one copy to send back to us to acknowledge you received the paperwork. And then I think the 42 days starts upon his receipt, correct? Or today, Ms. Bruggeman?
Yes, he would need to sign, and then obviously that there's the other section where he needs to request counsel.
Yeah.
So because he's in prison as opposed to live, like in sentencing, he should just, in my opinion, do both, if that's what he wants to do.
So, Mr. Williams, when you fill it out, it has a section to request appellate counsel through the state appellate defenders. So you can go ahead and mark that, and then the paperwork gets processed and appellate counsel will be appointed to represent you on that as well. All right?
Yes, ma'am.
All right. Good luck, Mr. Williams. Thank you.
All right. Have a good day, Your Honor.
You as well. Thank you.
Thank you, Your Honor.
And I do believe, Ms. Adams, any information on Mr. Montoy?
Judge, I just got a voicemail on Mr. Montoy. I just left a message. I don't know.
Okay. All right. so Mr. McCready, I'm just gonna set this for another day and we'll mail out a notice. All right, Mr. McCready?
Yes, that's fine. Thank you.
My next available is June 10 at 8:30 in the morning. And Miss Adams, if we could mail the notice on that, please. So June 10 at 8:30 in the morning in the matter of the people of the state of Michigan versus Walter Nelson, file number 25-22209FH. All right. And I do believe that concludes our criminal docket. All right.
Thank you, Your Honor.
See you guys. Thank you all. Have a good day.